In the meantime, we've got the ongoing debate about Neil Gorsuch for the Supreme Court. Will the Republicans go nuclear? I don't know. Hans von Spakovsky is our guest right now from the Heritage Foundation. Hans, how are you?
Hey, I'm doing all right.
Good to have you on the show again.
Well, thanks for having me.
So I read an article this morning that was pretty interesting saying that, the Republicans can go nuclear on this, but if and when, because when is inevitable, that they lose power and the other side's got that kind of power, they could put in a $15 an hour minimum wage or anything they wanted. So they're not sure it's in the Republicans' best interest to change it.
Yeah, but that's the legislative filibuster. The legislative filibuster still is in existence. No one is talking about changing the legislative filibuster. All they're doing is completing what Harry Reid did. And let's recall, what Harry Reid did was he changed the rules so that you could no longer filibuster anyone nominated for the executive branch, so, the Attorney General or the head of a Department of Defense, and you could no longer filibuster judicial nominations for the lower federal courts, the federal district courts and the courts of appeal. They only retain the filibuster for the Supreme Court, and the only thing they're talking about is basically completing what Harry Reid did and getting rid of the filibuster for the U.S. Supreme Court, not getting rid of the only filibuster that will then remain, which is the ability to filibuster proposed bills and legislation.
Right. Yeah. I was reading that article in the Washington Post today. They were referring to a New York Times report that senators on both sides are worried this could ultimately lead to the elimination of the filibuster on legislation as well. So I guess they see it as a slippery slope argument, right?
Yeah, but let me put it to you this way. A month before the last election, when the Democrats were absolutely 100% confident that they were going to win the election and Hillary Clinton was going to be the president, Chuck Schumer and others made it very clear to the press and elsewhere that when Hillary Clinton was elected, they intended to complete Harry Reid's rule, and they were going to get rid of the filibuster for Supreme Court nominees because they were not going to allow the Republicans to keep her choices off of the court. The point of telling that story is that anybody who doubts that once the Democrats get back in control, that they will immediately, without a second thought, get rid of any remaining filibuster rules if they think it's necessary to pass whatever legislation they want or to get people nominated is, well, anybody who doesn't think that's going to happen, I've got some great swampland in Florida I'll be happy to sell.
What did you read this story today that they're trying to allege somehow that Neil Gorsuch plagiarized something in a book that he wrote?
I did, and the author of the Law Review article, who he supposedly plagiarized something from, has already stated publicly he did not plagiarize my Law Review article. So this is a completely made-up story.
It's fake news.
Yeah, it is.
But they're reporting on it, obviously, because the media so often these days seems to be complicit in whatever the talking points are that day for the Democratic Party. I can't help but to point that out. It just seems so obvious. Do you think, I wondered about this on Monday after he passed out of committee, do you think this is all posturing on the part of the Democrats and they'll try to strike some last-minute deal to avoid the nuclear option maybe tomorrow night or something like that?
I used to think that, but I kind of changed my mind about it. It's very clear to me that Chuck Schumer has what I think you would call a scorched earth policy on the judiciary. And what I mean by that is they are willing to do absolutely anything to keep the liberal hold on the judiciary that unfortunately is prevalent throughout the United States. And I just think that, like I said, they are willing to fight, even if they think they may lose this, they're going to put up the biggest fight they can because that is their end goal.
Yesterday, getting back to the importance of Gorsuch being placed on the court and his originalist beliefs, Yesterday, a liberal appeals court ruled that the Federal Civil Rights Act extended to LGBT employees, even though that term didn't exist when the act was written. I read that there's a very good chance that's going to end up getting to the Supreme Court at some point.
Oh, yeah, that issue. And look, I could go through case after case after case over the past 2 decades where it was a 5-4 decision over very basic fundamental rights that we enjoy under the Bill of Rights and the Constitution, like the Second Amendment. That was a 5-4 decision upholding the Second Amendment in the gun cases involving the city of Washington, D.C., and Chicago. And it was very clear from those cases that the 4 liberals on the court don't believe there is a Second Amendment in the Bill of Rights. And without Gorsuch's vote on there, basically we could write the Second Amendment out of the Constitution. And that's why his vote is so crucial to maintaining the Second Amendment, First Amendment rights, all kinds of other issues where the court has split.
You know, Judge Diane Sykes, who was mentioned as a Supreme Court candidate, is the one that wrote the dissent in that case. And I loved reading it. And as I was reading it, I was thinking, boy, I hope Neil Gorsuch agrees with this because it made a whole lot of sense. So,
Oh yeah. And listen, if Donald Trump gets another appointment, which is, very likely, both prior presidents got 2 choices, she would be a fine candidate for the next Supreme Court justice.
She would. Hans von Spakovsky, the Heritage Foundation. I direct people to heritage.org. Thanks for your time.
Sure, anytime.
All right, Hans, take care. Thank you very much. Listen to what Diane Sykes said. So in other words, a liberal appeals court, the 7th Court of Appeals, stacked with Democrat-appointed judges, ruled that the Civil Rights Act, passed in 1964, extends to people claiming they were fired because they were lesbian, gay, bisexual, or transgender. And here, when we talk about the difference between activist judges and originalist judges, compare and contrast. The chief judge in this case, Diane Wood, a Clinton appointee, said that that this lady's case, who was a lesbian, claimed she was fired for being a lesbian, was covered because she claims it's no different than claims brought by women who were rejected for jobs in traditionally male workplaces years ago, and that the law must be updated to apply to conditions that didn't exist when the law was written. No. This is legislation. If Congress wants to go back and readdress the wording of the Civil Rights Act to add this, that's on Congress. It's not the place of judges to legislate. And Diane Sykes, who, as Hans pointed out, is on the short list for the next Supreme Court opening, had to say this in dissent. She said this law does not spell out protections for LGBT workers. Quote, "We are not authorized to infuse the text with a new or unconventional meaning or to update it just to respond to changed social, economic, or political conditions. Drop the mic and walk away." And when that case gets to the Supreme Court, they're going to agree with Diane Sykes. Thank God, because Neil Gorsuch will be there already.